Hello, everybody. This is week 10, and we are going to discuss employment laws and issues. Let's start. So, agenda is Introduction to Employment Law, Fair Labor Standard Acts, Human Right Laws, Equal Pay Law, Health and Safety Regulation, Family and Medical Leave Act, Employee Privacy Rights, Unlawful Termination Law, employee benefit laws, disciplinary action and performance management, international employment law, and conclusion. Now, understand that employment laws form the foundation of regulations governing the relationship between employers and employees. Understanding and complying with these laws are crucial for organizations to operate ethically, protect employees' rights, and build trust with stakeholders. Failure to adhere the employment laws can result in severe consequences, impacting both the financial health and reputation of the business. Legal frame, framework overview is employment laws establish the rights and responsibilities of employers and employees in the workplace, covering areas such as wages, safety, discrimination, and much more. Compliance importance. Adhering to employment laws is essential for organizations to avoid legal penalties, promote fair treatment of employees, and maintain a positive reputation. Business impact. Non-compliance with employment laws can lead to lawsuit, financial losses, damage to company reputation, and employee dissatisfaction. Fair Labor Standards Act, it sets standard for minimum wage, overtime pay, and other labor practices. Understanding the history, key provisions, and informants of the FLSA, Fair Labor Standard Act, is essential for employers to ensure fair compensation for their employees and maintain compliance with the federal labor law. Understand that employees must pay at least the federal minimum wage and provide overtime pay at the rate of 1.5 times the regular rate for hours worked beyond 40 in a work week. Do you get that? The minimum wage for each hour worked by non-exempt employees, overtime pay at a rate of 1.5 times employees' regular rate, all works hour by non-exempt employees over 40 in any work week. Special rules for tipped employees who get tipped, payment of wages on regular pay days, and restrictions on wage deductions, employer record keeping, and equal pay. Federal law establishing wages and hour standards for most public and private employers. The basic recruitment include break time requirements for nursing mothers, special rule for child labor, special rules for state and local government employing that involve fire protection and law enforcement activities, volunteer services, and compensatory time off in lieu of overtime pay. Let me share this again so that we can. That's fine. Let's continue. So in today's video, that's right. Captain need to know. Red flags. Big principles. First, let's make one of the biggest distinctions. Employees oftentimes benefits such as health insurance, paid time off, and others. We will talk about that in just a minute. Please, if you have the right to refuse, you have a right to know information, training, and supervision you need to protect yourself. In keeping your workplace healthy and safe, which may include select and safety representative or community member. Or procedure. Should anything happen, adequate healthcare access as well. Now, result in termination of the person.
Read the agreement in great detail. Some details to be yeah. General rule of thumb would be the first day you begin the work. And working for a person that has not provided employment agreement. If something goes wrong, role responsibilities. Your contract should clearly state for adding more responsibilities. An amount should clearly stated in the agreement. I stated weekly hours worked. The frequency of payments must also be for workers to be paid at regular each program set a minimum wage and should hours of work. Most businesses have regulations on that, as well as mandatory to give you a 30-minute unpaid break in two 15-minute breaks. By the Ontario Employment Standards, they are entitled to 1.5 times of the normal pay for each hour they worked overtime. They're entitled to paid and unpaid leave, such as sick leave, return. There's additional unpaid sick days have been After you have completed 5 consecutive years of employment, after you've spent 10 years with the same employer. Vacation time is also associated with your employer. If you ask, you may not necessarily just not show up at work the following day. They not fire you without a cause. It happens for other reasons for required. It is typically from 1 to 8 weeks, depending. Well, in Ontario, you should give a 2 weeks notice in advance to your work, at least a year. Once your employment ends, your company and the total compensation you receive. This document is important for you. So might want to apply for detail, but if you want to see a workflow, let's talk about vacation time. Oh, most provinces in Canada the employers also have violence. The employers usually come days are usually paid for like with all fundamental rights. right to do. They could not ask you to pay your equipment. If they do, this is like this. Has no influence on your system. Next, the employer cannot if you are sick or they cannot what hope will be. Next, the employer cannot question you. That means they're trying to get away from paying you a termination for some your rights, different employment types, and taking broad career while standing up for your rights. If you found this information helpful,
Now let's understand human rights law, protection of employee rights, discrimination law, workplace harassment policies. So human rights laws play a vital role in protecting the rights and dignity of employees in the workplace. By prohibiting discrimination and implementing harassment policies, organizations can cultivate a culture of inclusivity, respect, and equal opportunities for all the employees. Employee rights protection. Every person has the right to equal treatment in employment without discrimination based on code core grounds. In Ontario, about three-quarters of all human rights claims come from workplace. Employment is used in a very general way in the code. Employees, independent contractors, and volunteers are covered. Human rights applications can be filed against employers and also against contractors, unions, and board of directors. Employers and unions have a joint duty to make sure that the workplace are free of discrimination and harassment. The right to equal treatment with respect to employment covers applying for a job, being recruited, training, transfers, promotions, terms of apprenticeship, dismissal, and layoffs. It also covers rate of pay, overtime, hours of work, holidays, benefits, shift work, discipline, and performance evaluations. People with disabilities have the right to be provided with the equipment, services, or devices that will allow them to do their job. In employment, you must be at least 18 years old to file a claim stating that you were discriminated against because of your age. There is no maximum on the right to freedom from discrimination in the workplace because of age. This means that older person who feel that they have discriminated against based on their age may file a human rights claim. Then, employment and record of offenses. When you apply for a job, you cannot be asked if you have any kind of criminal record. However, employers can ask whether you have been convicted for a federal offense for which you have not received a pardon. You may be asked during an interview whether you are bondable, if that is a requirement for the job. Employment and union. If you are a member of a union, you may have the right to file a grievance under your collective agreement. Check with your shop steward or representative. Employers cannot come to an agreement with a union or an employee that some or all the codes does not apply to them. Also, if a union does not support an employer's efforts to meet its obligations under the code, a human right application may be filed against the union. Employment and creed. If you have the right to employment that respects your sincerely held beliefs and practices, you may have religious and creed based needs such as prayer breaks, religious or creed based day off, and dress requirement. If you ask your employer to meet these needs, they should be met unless your employer can show that it would prevent from you from doing essential duties of your job or would cause undue hardship based on cost or health or safety risks. In Ontario, employers can meet their duty to accommodate time off for religious holidays by searching for solutions that allow time off without adverse employment consequences, include a loss of pay. However, forcing an employee to use vacation time instead of exploring other options would likely to be found discriminatory. Providing several alternatives and choices is always preferable. Height and weight requirement. Minimum standard of height and weight sometimes unintentionally screen out certain job applications, such as women and racialized person. Such a standard is only allowed if it was adopted for a purpose or goal that is rationally connected to the function being performed, was adopted in good faith in the belief that it is needed to fulfill purpose or goal, and it is reasonable necessary to accomplish its purpose or goal in the sense that the person cannot be accommodated without undue hardship. The ultimate issue is whether the person responsible for accommodation has shown that accommodation has been provided up to the point of undue hardship. Employment medical examination and drug or alcohol testing. Drug and alcohol dependencies as well as perceived dependencies may be considered a form of disability under the code. While not all people with drug and alcohol dependencies see themselves as having a disability, they are protected under the code against discrimination in the workplace on the ground of disability. Testing for alcohol and drug use is a form of medical examination. Employment related medical examinations or questions as part of the job screening process are prohibited. Medical examinations to determine the ability to do essential job duties should only be used after a conditional offer of employment has been made, preferably in writing. If an employer cannot show that it has an effect on job safety and performance, drug and alcohol testing has been found to be violation of employee rights. Employment agencies. Employment agencies cannot discriminate. They also cannot discriminate at the request of a client. For example, an employer asks an agency to send them a young, attractive woman for a receptionist position. This would be discrimination based on age and sex. Section 23 of the code talks about the issue in employment, such as jobs, applications, medical examinations, or inquiries and interviews. But you understand how people discriminate? They just write things which are not um, which cannot be caught. If somebody want to hire somebody, they will give better grades on the interviews. You understand? So whatever we are reading it's business law related to business. But in real life, you will see lots of discrimination. Just try to identify if you think that there is a discrimination, you must raise your voice. Harassment in employment. Harassment means comments or actions that are unwelcome viewed or should be known to unwelcome. You have the right to be free from humiliating or annoying behavior that is based on one or more code grounds. Harassment requires a course of conduct, which means that a pattern of or behavior or more than one incident is usually needed. It does not matter what type of business or employment it is. Harassing behavior based on code grounds in any employment setting is prohibited under the code. Harassment in the workplace also prohibited under the Occupational Health and Safety Act. Let's watch this.
To you, and also where to find additional resources. You may have read other legislation or the common law. The ministry has prepared the employment standards poster, which brings some of you. Make me work 10 hours again today. Ontario, there are daily and hours. The daily maximum be in writing, including electronically. Weekly So I can only give you $10 an hour. Most employees visit Ontario.ca. This is coming up due. When am I going to or wage statement on or before are entitled to 2 weeks of paid card. In most cases, employees live while employees with 5 or more years are entitled to of gross wages earned in the vacation lump sum, paid vacation time. But if you work electronically or in writing, vacation pay can be paid on vacation time and pay. Read the vacation time. Oh, it's so busy today. There are 9 public holidays in Ontario every year. Most employees are entitled to take these days off. Some employees work in industries where they have to work a public holiday. If you're on strike, your regular pay plus a different day off with public holiday pay, or holiday pay plus premium pay, which is at least 1.5 times your regular rate each month on the holiday. To learn more about public holidays, you're protected full-time, part-time, permanent, or term contract employee. There are a number of different ways you may be entitled to pregnancy, parental, family responsibility, family caregiver. Cases, they must return you to your job when your leave is over. Information needs to be in your time employment standards. In most cases, if you're terminated, you must give either notice of termination pay, or a combination of both. The amount you may be entitled to depends on how long you work for your employer. You're only eligible if you've been employed continuously 3 months. To find out if you might be entitled to something, try your termination at ontario.ca/. of a reprisal. Reinstate you. Information Center at 1,000. And ministry in a number of different ways. To unionized employees should talk to their union representative. There are other ESA rights and special rules that information is available in English.
Let's understand equal pay law. Equal pay laws focus on eliminating wage disparities based on gender and other protected characteristics. By embracing pay equity legislation and implementing fair compensation practices, organizations can foster a more inclusive and equitable workplace, enhancing employee satisfaction and reducing legal risks. What is gender pay gap? Equal pay law aims to address disparities in pay between genders, promoting equal compensation for equal work and skill, and reducing gender based wage discrimination. Pay equity legislation. Legislation prohibited wages discriminated based on gender, race, or other protected characteristics, requiring employers to pay employees fairly for their contributions. Fair compensation practice. Organizations must access pay structures, conduct regular pay equity audits, and implement transparent compensation policies to ensure fair, equitable pay for all employees. Pay equity in the central feature of the Act is that it requires employers to establish a periodically update a pay equity plan. In developing a plan, employers must identify the different job classes made up of positions in their workplace, determine whether each job class is predominantly male or predominantly female or gender neutral, determine the value of work for each predominantly female or male job class, and compare the compensation between predominantly female and male job classes doing work of equal or comparable value. Employers have to establish their pay equity plan within 3 years of becoming subject to the Act. Once the plan is established, they will also have to increase the compensation of any predominantly female job classes that are receiving less pay than their male counterparts. And we also need to understand the reason why the pay gap is there. If there is any logical reason, for example, if a physical labor is required, then it should be mentioned that this much money will be paid to somebody who can do these kind of jobs. If it is mental work, then you must have some criteria, like you must score this much in this kind of test to get this kind of salary. Let's watch this now.
Imbalance. When I'm a grade 6 student, imbalance is very okay. And stuff like and so um, that that look for a job. Why is that? Well, this is because to display with solutions solve this problem. For my teachers, and like myself, the kind of process the term gender wage gap is the difference between having the highest gender wage gap and for and traditional men's work. Some different between women's work or early childhood educator, nursing, or social the wages for that job become lower. Let me give you an example. Pattern 97%. It's not more, and it's not provided. All of these categories of jobs is women in minimum wage jobs. So, you know, the problem is the majority of jobs now. About mortgage, bills, car payments, food, everything's- and also because parent responsibility is taking care of health, which includes cooking, and change our minds to come up with solutions to solve this problem. Up with that can help narrow the gap. First, we need to eliminate barriers for women to get so when you have the other girls out there. So I understand the sign of accent hat on a t-shirt. I also did for my social studies on gender discrimination. And that 53% of women right environment, women are and will continue. Studies have shown that
Let's not get influenced by whatever people say, but try to understand what is happening and why it is important for us to understand these. Now, understand health and safety regulations. These are crucial for maintaining a safety and healthy workplace. By adhering to established standards and regulations, businesses can safeguard their employees from potential risks and create a culture of well being and security. So, workplace and safety standard is establishing and enforcing regulations to ensure a safe work environment, reducing risk and preventing accidents. OSHA means Occupational Safety and Health Administration standard to protect employees from workplace hazards. Family and Medical Leave Act. It provides essential protections for eligible employees to balance work and family responsibility. Employers must understand their obligations, provide necessary support, and ensure compliance with FMLA regulations to support their workforce effectively. Employee privacy rights, data protection, monitoring policies, and confidentiality agreements. Employee privacy rights are fundamental in the maintaining trust and confidentiality in the workplace. Organizations must implement robust data protection measures, establish clear monitoring policies, and enforce confidentiality agreement to uphold the privacy rights of their employees. Unlawful termination laws. Unlawful termination laws protect employees from unjust dismissal and ensure fair treatment in employment relationships. Employers must be aware of legal obligations, respect employee rights, and handle terminations with transparency to adhere to labor laws. What is wrongful dismissal? It is understanding the grounds for unlawful termination, such as discrimination, retaliation, or breach of contract. Reasons for legal action, identifying situations where employees may pursue legal actions for wrongful dismissal, seeking remedies and damages, employee rights and terminations, ensuring fair treatment and compliance with labor laws when terminating employees, providing severance packages and support services. So we will not watch this video completely. I'll play a few minutes and then we will go forward. Welcome everyone. This is Andre Moslangi from Plus Canada. Before we begin, just go and you're in a different province, you can locate the law society of that province. Okay. Misconception number always is, are you really laid off?
say this thing. Layoff resulting. Determination is fair and they can proceed on with their lives. Your entitlement to this is a lot of times people when people are terminated. They conclude that that's all they're entitled to. In terms of what you're entitled to in the statute. So it's a common description. If you when the employer terminates you, they need to have a just reason. It's calling us and saying, I any employee at any time employees have a dream of it's correct. And I guess this comes from, all these somehow they tend to believe that.
All right, so let's move forward. Employee benefit laws, the healthcare and retirement benefit, and compliance with ERISA regulations. Healthcare mandate means complying with regulations related to employee health insurance coverage, including Affordable Care Act provisions and reporting requirements. Retirement benefits are basically providing retirement saving options such as 401k plans and ensuring compliance with Employee Retirement Income Security Act regulations. Compliance with ERISA regulations means following guidelines to protect employee retirement savings, disclose plans, connect information, and adhere to responsibilities and disciplinary action and performance measurement. So, discipline, disciplinary actions, and performance management play a crucial role in maintaining workplace standard and productivity. By following legal considerations, implementing fair evaluation procedures, and utilizing progressive discipline strategies, employers can address performance issues effectively and ensure compliance with employment laws. And in conclusion, maintaining compliance with employment laws is essential for mitigating risks and fostering a fair and inclusive workplace. By taking proactive measures, leveraging resources for continued education, and prioritizing legal compliance, organizations can create culture of integrity, respect, and accountability that supports both employees and the business.